May I please, your lordship? I have to mention for listing. So matter may come up
What kind of matter?
uh, revision, criminal revision.
Criminal revision.
Yeah.
What at what stage?
This notice was issued on
No, 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 whatever.
2024
It has to be in the admission stage, order column, order column.
admission.
Yes.
Published.
Lordship, with the consent of my learned friend here, actually, I beg to mention item number 20, Lordship. So, can it come on 23rd of March, Lordship? Yeah. Only they have received, Lordship.
Are you on? Is any interim is there? That means case is still under investigation. No, no, no. Stay is there. Otherwise, investigation stage.
Yes.
Now, say case is at the stage of investigation. Okay, then. You, in that case, you return the case there. You are Mr.
W. Sharma, Lordship.
Mr. Venkatesh. This is the one which
Lordship, can I
Mr. Sharma till an edition people there is no objection. However, it is submitted by Mr. Sharma that CDC let the CDB return back, directing the High Court company to its direct honor for next based according to 26 of 26 of
Lordship, there is an interim.
interim be continued till next.
Obliged.
May it please, your lordship. Lordship, may I pay for listing of criminal petition, pending petition, lordship. It is in the admission stage, lordship. In the next week,
Maybe on 25th.
Obliged.
Yeah, please, Your Lordship. I beg to mention criminal revision petition number 251/2024. Is last listed on 15/7/2024. Thereafter not listed. Notice was
And this week too, we cannot list. We don't have any.
it may be listed in order.
What you have submitted? No, this week we cannot list. We are listing it on
Any convenient date.
any convenient.
Any
Okay, then 25th of this month.
Make this lordship. Lordship, praying for listing AB, my lord. Day after tomorrow, my lord.
Day after tomorrow?
Yes, my lord.
No, no, no. Not at all.
Lordship,
Maybe on Monday.
fresh matter, my lord.
Monday.
Monday.
23rd.
Obliged, my lord.
There's no urgency.
Please, Your Lordship. Tomorrow, there are two criminal petitions which have been fixed, my lord. This is a third petition which is connected with the same case. Actually, they had filed 3 criminal petitions for quashing of 498A and DP case. 2 have been listed tomorrow. This has not been listed, and there is a possibility of sending this case for mediation. So tomorrow there will not be any hearing on that one. May I pray that this may come up tomorrow along with the other? Deeply obliged.
You give the numbers of the other petitions.
Maybe this lordship. I beg to mention item number 19. Pass over for
Item
that.
number
19.
19.
Yes.
Ah.
Pass over for the.
Why? Mr. Hawk is not there or what?
He's here living personal difficulties.
Have you taken the consent of the other side because it is the private case? Have you taken consent
yes.
of the other side?
Yes, sir.
Tell us.
Yes.
Have you taken consent
Yes, sir.
with the consent of the other side? So you are Mr.
Islam.
Counsel bidding. Counsel Mr. A is the bid one. Mr. F. Bid for nature. Due to personal convenience. Mr. Hawk was not in a position. Proceed with the case. Test the matter accordingly after 2 weeks as an indictment. Was there any interim? Was there any interim?
No, this is family matter.
No, interim is any. Is there any interim order?
Yes.
Is not sure. Item 9. Whenever you come to this, make a submission.
No
just
interim
go
order,
through the
Lordship.
case record. Was saying yes, now you're saying no. We don't know. We just want to help you with that.
Sorry, my lord, I'm for 19 lordship. And today, my lord, to answer my personal difficulties to.
That is okay. I have already.
Interim is there, lordship.
Interim was there.
Lordship.
No interim.
Interim means lordship with the earlier lordship and the maintenance is grant 15,000 lordship and that is reduced to lordship. 7,000.
Where it is? He'll return it. Oh, well, you are directed to pay 7,000 per
Lordship, Lord. But we are paying, Lord.
interim continue.
Blush.
Just a second. It is for next date off or it is till disposal. It's not here. It is most probably till disposal, I think.
Lord.
So there is a question of interim because till disposal of the present petition that was allowed. So it will continue.
Blush.
May it please your lordship, I beg to pray before listing these three revision petition for admission lordship. For admission lordship revision.
Can it be possible on 25th, either on 26th? Maybe on 26th.
If possible, 25 lordship. If possible, lordship, 25 it can be fixed if possible, lordship.
And many matters have already been listed. I think.
25 submission matter has done by
Yes,
ma'am. 27 if possible, ma'am.
27.
Lordship, I'm praying for listing of a criminal petition pending matter, Lordship. Last listed in the month of January.
January. On 26th of this month.
May I please your lordship? I'm paying for the listing lordship AV. Some matter lordship.
Be
Monday,
on Tuesday, 24th.
Monday.
Monday may not be possible. 20.
May I please your Lordship? I beg.
Hmm.
May I please your Lordship? I beg to mention for listing of a criminal petition, Lordship. Pending matter, Lordship.
26th.
Thanks.
Wait, please, Ladyship. Ladyship, I beg to mention one criminal petition for listing. Lordship, it's a fresh matter. Lordship, if possible, kindly be fixed on 25th of March, sorry, February.
May I please your Honor? Beg to mention item number 17.
17.
17. Kindly, I adjourn the matter for the day. I'm on behalf of the G. Gogoi.
G. Gugoi. You are MS?
SD India.
SD in. But it is SD in. With the consentment on the state is there, I think. No, only state is there. Here they appearing on behalf of Mr. G. Wait for an short prayer allowed. Disseminate accordingly after 2 weeks. Is only date 2 weeks. Okay, it will be listed after 2 weeks.
May it please your lordship. Lordship, I beg to mention item number 31. With the consent of the other side. Lordship, in this matter, we need to file a reply to the objection that has been filed by CBI, Lordship.
CBI has already filed.
Yes, Lordship.
You are Mr.
A Chand.
H.
A Chand. A Chand.
H.
A for apple. A Chand. CHAND. ACHAND.
Alam.
No. A dot CHAND. Yes. CHAND. AND.
You are.
Lordship, let the matter come up after the first week
They
of
need
March.
some time to file their reply against the written objection filed by the CBI. How many weeks you need?
After the first week of March, let the matter come up.
First week of March.
March, yes. First week of March. And there's Lordship, there's also an interim order.
9th
That the-
of March. It will be done.
Obliged, Lordship.
May I please your lordship?
Double A. Which one?
May I please your lordship? I am praying for listing of a criminal petition of 143, 2024 for order. Obliged.
It is your lordship. Lordship, I beg to mention item number 35, lordship. In this case, a case has been registered against the petitioner, lordship.
What is
In
it?
this case, a case has been registered, lordship. This anticipatory bail has been filed with regard to a non-FIR case, lordship. Before filing of the FIR, this case was, this anticipated bail was filed, Lordship. I am on interim, Lordship. Recently, I came to know that the case has been registered against the petitioner, Lordship.
Now, what is your claim?
So this may be
Disposed of
disposed of first. 35.
35 is it? Have you received any this information? Possibly he has the information.
Fine.
You have the information.
Lordship, a case has been registered, Lordship.
So that is your information.
Lordship, yes.
It should be about and it is submitted by this information. The case has already been registered against present petition. And the case and the instant petition is by prior to the registration of submitted matter may be disposed with matter may be according to. But we cannot extend your interim now.
Lordship,
And as the case has already been raised, present AB some fractions same has been disposed. The interim granted and item stands
Lordship.
disposed. Okay.
Oblige, your Lordship.
May it please your lordship. I have instruction from the client through an affidavit, lordship, that I have to withdraw this matter. So, lordship, after some time, I will play this withdrawal letter before the court master, lordship. That may be kept on record.
Time being, it's keeping it for time being.
Lordship may allow withdrawal, and that may be kept on record. I will supply after some time. I will supply.
I mean, your client was furnished and
Yes, lordship, he notarized an affidavit through an affidavit saying that I have to withdraw this matter.
RMS is submitted by S. Chaudhary that she has been notified by her petition to withdraw this according she paid for that the affidavit which is sworn by the petitioner authorizing her to withdraw the case may be kept in case may be kept with case with the above observation the present petition stands disposed on with. You just furnish us.
Lordship, oblige.
May I please, Lord?
Yes.
My lord, on the instruction of the petitioner, my lord, I am going to this matter, and in this case, my lord, the charge sheet is submitted. That is why they are not interested to pursue furthermore here.
Submitted that's what they are interested to proceed with the case on being as the case has already been transferred. In view of this case is already disposed.
Obliged.
May I please, your lordship. It is a bail application under section 483, my lord. Offense is under section 64(1) BNS. My lord, FIR page 13. My lord.
It is a charge case, man.
Yes, I will say. Yeah, FIR page 13. I may be allowed, my lord, to read. May I read, my lord? The humble statement of information is that on 15/11/2025, at about 11 p.m., the above named accused person took advantage of the fact that no one was present in my house and he hid in the corner of my house. The accused person suddenly caught me near the water pump, Damkal, post gamosa on my mouth and threatened me with a knife and warned me not to make noise. Thereafter, the accused person laid down me on the ground forcefully near the water pump and raped me. It is mentioned that
I have found one order, my lordship's order, my lord.
Oh, that's
It was
one.
disposed of. We on charge sheet, being with charge sheet, my lord, it was disposed. That's
That
why
was not, that was
my-
not
that is
disposed on
not in the
married
order,
object.
my-
Why this kind of things are going?
And that is page 31, my 32, 11.
Base 31.
11% page 32. That's why I am also searching why it is taken.
Hmm. No, this is not disposed on married.
Only search it on
Because of
search it.
statute, a simple order was there. We take less of Dr. Is this this one? I enacted to scan for disability call. এবার আপনাকে কব ম্যাটারগুলো চাব লাগে ডিসক্লোজ মেৰিটটো ডিসক্লোজে হোৱা নাই মেৰিটটো ডিসক্লোজ হ'লে তথাপি বেলেগ কথা আছে এনিৱে এইটো দিছোঁ বাৰু চেম ডে 93
Right.
93 scan copy of the PCRP call for along with the case data distribute to the same order 93 okay.
May please, your lordship.
Yes.
Lordship, in this case, CD would be required, but the accused petitioner is a student of HS final examination. He will be appearing for his HS final examination, which will be commencing from the month of March, lordship. And 5 other petitioners.
Shall see your CBSE or what?
Lordship, he is under the National Open Schooling Medium.
Acha open school.
Lordship, and 5 other petitioner accused persons.
When he is I mean
Some
exam will
letters
be-
also teach on. This is the Golaghat case where one person died.
oh
That is the case, ma'am.
Acha,
All of
acha.
the students.
all the other matters are fixed on
Fixed on-
Lordship, the other matters are
26,
fixed on
na?
26 too, but 5 petitioners arising out of the same FIR and same allegation have been provided interim protection by the Honorable Court for appearing in the examination.
That was
That
Mohammed
was
said.
earlier by the
Your one
Supreme
is open university.
Right.
So we
Yes,
have to
but
wait for
but
students.
examination process is same, your lordship, because
What process? You're going to appear through your I mean open university, isn't it?
yes, but
Ah.
the courses are different, but examination will be same, lordship.
Your examination will be commencing from which date?
From the month of March, lordship. I have
Tell
annexed,
us the date when day, which date?
lordship, till the date of filing of the petition, exam routine has not been published.
Then
Therefore,
why was
Silent man.
on
That is
26 we are listing all the matters
along with
listed
the
on
other
26.
matters.
lordship,
There are some grounds we are giving some protection because
Lordship.
2, 3 are appearing on 11th of this month.
My lord, that's why
So that is the consideration. And 1 and 2 we did not consider because of some reasons.
lordship.
So 2, 3, 4, I think 2, 3 matters have been considered because they are going to appear. So interim was granted.
Yes,
But
lordship.
your petition, you don't even know when the pure matter will be
Lord-
commencing.
Lordship also some of the not considered as it is in the
It's not
month of
considered,
March.
yes.
In the earlier occasion also.
So your case will be in the same fitting we did that. Those,
Lordship, I am submitting,
so let the 26 page.
26. Along with
We
the
are
others.
listing it on 26
lordship.
along with the others. Okay. Call for the CD list on 26. We are listing it on 26. Let us see.
Yes,
CD.
but lordship, one submission is that petitioner, he is in a, he's not in a good mental state, so therefore he needed some time for preparation of the examination. As such
Okay,
unforeseen incident has happened,
What
lordship.
to do? He is not in a good mental situation. 2 people
Is the
died.
offense committed murder case?
They assaulted
Lordship,
people
he's
so
not at all
brutally they
involved in the
died.
murder.
See what to do with it. You may be a young person, you may be, we understand.
Yes, lordship.
Now your mental condition is not good. That time what had happened?
Lordship, if
Keeping in a birthday party, you were enjoying
No,
the
no,
birthday
no,
party,
Lordship,
and
if-
from there you have directly have
No, Lordship.
assaulted 2.
I have
Not because your mental condition, I don't know what is your mental condition. That time it was very good. We're listing it anyway, we're listing it on 26 with the others, we'll see to it.
much obliged, lordship.
My pleasure, Lordship. This is regular bail application, Lordship. Here in this case, Lordship, FIR will find page number 16, 16, Lordship.
6.
And Lordship, and in Gauhati area, Lordship, at Boragao, one in a dhaba, Dreamland dhaba, and one Bolero vehicle has been seized from the dhaba, Lordship. And Lordship, the present petitioner, Lordship, and he was in the inside the dhaba, and he is consuming the refreshing, Lordship. And suddenly police appear and the vehicle is seized, and subsequently, Lordship, the petitioner was inside the dhaba lordship, and he was arrested lordship along with other 2 person lordship.
Under
Lordship.
which section?
Lordship. Other 2 person were also
No,
there.
under which section he got arrested?
Lordship 180,
Here,
318 and 117 and fake currency note lordship.
take gold total weight
But-
1.391 kg.
But these are these are
500 FICN mallet, take Indian currency mallet.
lordship, these,
500 denomination, that is 99,500.
these are recovered from the lordship bolero vehicle that is
Mallet,
from
we
one
clear from
Rafiq.
CD mallet.
This is belong from one Rafiqul Islam lordship, and he was not there lordship. And lordship, another submission lordship, kindly come to page number
No, you were
20.
arrested from there in the dhaba, from dhaba itself.
Inside the dhaba lordship, but vehicle was parking inside outside of the dhaba lordship. But vehicle is belonging from one Rafiqul Islam lordship, but not Islam Ali lordship, and not from the present petitioner lordship. So something is recovered from inside the vehicle, not from their possession lordship.
So you were traveling.
Lordship, not in that vehicle lordship, and the other person lordship. And lordship, kindly for a moment lordship, page number last page lordship, page number 23 lordship.
23.
23 lordship. And after arresting lordship, and the WT message was sent by the Gorsuk police to the North OC North Lakhimpur lordship. No communication was to the family members lordship in connection with their arrest. And but in this lordship WT message lordship, there is nothing anybody has been received or communicate why he was arrested lordship.
What is it?
That is
It is the WT
48
message.
lordship. 48 notice lordship, that cannot be, and
Your
subsequently
petitioner got arrested in which place?
from the Boragaon lordship.
Boragaon means Gauhati.
Guwahati.
That's why WT
And
had to be.
that is why lordship Gorsuk police lordship sent this notice to the North concerned police station, North Lakhimpur lordship. That is not served to our family law.
No, that we cannot
Right.
say without
Without
case
CD.
diary. Now the question is that your petitioner, as per the allegation,
Lot.
I'm not saying,
Lot.
maybe correct, I don't know. But the question is that as per the allegation, the entire thing was recovered
From
when
one
you were
Bolero
there in the said dhaba, and it is allegations that you brought all this fake bull from Lakhimpur, not Lakhimpur. Not
Lot.
Lakhimpur. Lakhimpur is now become a
Lordship.
hub of this fake bull.
Lordship.
I don't know from why it is become. Can you tell us?
And lordship, actually, as per the contents of the FIR,
No,
lordship,
can you tell us why Lakhimpur is the main area?
no.
Every fake goal is from
Lordship,
Lakhimpur.
there are
Fake
number,
currency and-
lots of people, lordship, they are involved in like
Well, what?
He
Lots
is-
of-
Lakhimpur. No, I don't.
His earlier also 2 occasions he was arrested. Not same allegation.
That's why.
On that basis, actually, on that day, lordship, he was innocent, lordship.
But in earlier cases,
Earlier two
Earlier
cases,
cases, lordship, under already his release on bail, lordship, and subsequently, lordship, and under investigation or charge sheet not submitted.
now see, very surprisingly, in other cases also fake goal. And then in the said case also, he was with the
That
fake
was
goal. Even
not currency, lordship, not currency.
it is more than gold medal. Earlier,
Anyway, lordship,
People,
for that,
uh,
maybe lordship.
do people purchase this kind of fake gold, you know?
actually when it was sold mallet, it was origin.
Origin?
But
No,
when
not
it was sold mallet, then it is given the fake. Fake mallet, fake gold mallet. When people
But I'm
came,
not following you.
when people came different places mallet, they targeted that person mallet. They sold the original gold. When they are saying that it was original, they purchased, advance was also given. Thereafter, when it was given to them, they given the fake. Origin is hidden and fake gold is given.
Now see, we do not have any even courage, I will call, to purchase 1 kg of gold. Now, even 10 gram is difficult.
Right. Present.
Now they are purchasing
Lot.
1 kilo more than
But they are also greedy, lordship.
obviously.
Passenger also, lordship.
Okay, then when it can be listed?
Not that lordship, it is from Gorsuk lordship. Otherwise, lordship.
Minor 5th of March.
It is full of cases.
Yeah, got nothing.
Gorsuk. It is from Gorsuk.
Also,
We don't have the-
nothing.
Maybe course. কিবা পাৰি নেকি কিবা আছে নেকি She is saying the 2nd of admits, 2nd of March can.
March.
Okay, 2nd of
Published, lordship. Published.
Next is also same.
Same.
Oh,
But
for
that
these
it is
two
from
petitions.
GRPS, lordship. And they are from lordship, outsider from Bihar, lordship. But actually, they
He is
are
from
the
Bihar.
They are
they are the
part-
scapegoat. Actually, they are lordship.
They are the procedure, madam.
But they could not, Lordship, they could not commit anything, Lordship, but suspectively,
He
Lordship,
had
they were
UP
arrested.
from that places there to purchase gold from Assam.
From that to from Lakhimpur.
The
Okay,
Lord
2, 3, we are listing it both.
Lord.
times.
Lordship, three, Lordship, 3 of March.
2nd of March.
Second.
3 is a holiday.
And
3rd is a holiday.
And one day left, Lord.
Fifth month, then fifth month. Fifth month.
5th, you can
Third.
take, but there are many matters. No,
Sixth, then 6 month.
6th is what? No, not 6th.
3, 4 holiday.
6 holiday.
6th of
5th, Lordship. Can it be, Lordship?
Pariban. Already.
49 days. My lord, they are in 49 days in custody. Can it be 28, Lordship? 49 days in
No,
custody.
sorry, 6th of March. If we have some difficulty on 5th, let it be on 6th.
Obliged,
Otherwise, I was giving you on 2nd of March, but you are saying that you have some difficulty, to let it be on 6th of March.
Obliged, Lordship. Obliged.
6th of March.
Prohibit is a regular bail application. Petitioner is behind the bar, Lordship, last 72 days of it.
72 days.
2 days. FR start from page number 9, Lordship. Relevant is page 10, Lordship. I would like to read, Lordship. Respectful submission is that almost 5 years back, my daughter, namely so-and-so, got married with the above named accused number 1 as per Muslim Shariat. During the time of marriage, a pair of golden ring, furniture, etc. were given for the benefit of my daughter and son-in-law. After 5-6 months of marriage, the accused person sold the ornaments and household articles given at the time of marriage and demanded rupees 1 lakh from my daughter and inflicted physical and mental torture upon her. During their conjugal life, 2 children were born out of their wedlock, namely so-and-so. About 1 week ago, the accused number 1, upon the conspiracy of other accused person, again demanded rupees 1 lakh from my daughter. And as she did not meet the demand, the accused person assaulted my daughter and driven her out from the house along with her second child, keeping the first child with him. On 28/11/2025, at about 4 p.m., the accused number 1, along with 2 other unknown persons, forcibly had taken away Ariful Islam from my house and demanded him from us over phone by counseling him. It is very much urgent to recover my grandson from the custody of the accused. Lordship, here basically allegation apparent from the FIR, Lordship. Lordship, here the section I would like to refer page number 11, Lordship. Here the case has been registered, Lordship. Unfortunately, Lordship, section 90 subclause 2, Lordship. Kindly see, Lordship, for a moment whether there is any whisper or ingredients, Lordship. Section 92 of BNS. And the rest of the sections are available, Lordship. Section 90, death caused by an act done with intent to cause miscarriage, Lordship. Lordship, how this section can be, Lordship, attract in this instant allegation, Lordship. So, Lordship, even admitting the fact, Lordship. And the rest of the sections are available, Lordship. So, Lordship, his detention is illegal, Lordship, and he has an indefeasible right to release on bail, Lordship. Lordship, one judgment of the apex court, Lordship, I would like to refer regarding this point. What is the 2009 4 SCC 446, 446, Lordship. A Lordship can from this. Lordship, paragraph number
Just
the other sections are bailable, Lordship. I have said.
the 137.2 is also bailable.
Bailable, yes, exactly.
137.2.
Yes, bailable, Lordship.
How?
Yes, Lordship, kindly see the chart, Lordship. I checked, Lordship. It is bailable offense.
Where from you're saying?
Yes, Lordship. Yes, Lordship.
Then it did 137.2.
Yes, Lordship, from the
137
start.
subsection 2.
Yes. Yes, Lordship.
Because it's extended up to 7 years.
Yes, Lordship.
Still it is bailable.
Yes.
Is it Sharma? You
Well,
check.
yes, it is bailable offense. Classified offense is bailable.
Huh?
The classification of offense is bailable.
Again, I'm asking where from you're saying bailable.
Yes, Lordship, kindly see the chart I have. 137.2.
No, 137.2 you read 137.2.
So yes, this is the chart.
Now see 137.2 is there where whoever kidnapped
No, Lordship, the
a
classification.
person from India or from the legal or
Yes, Lordship.
shall be punished with
Lordship, there is a
imprisonment either
specific,
restriction
Lordship.
for a term which may extend it to 7 years
Yes.
and shall also be liable to fine.
Yes. Lordship, kindly see the table.
Yes.
Kindly see the table, Lordship.
How it can be.
Yes, Lordship. This is
I cannot follow this. It's up to 7 years punishment.
7 years. Classification.
It's bailable.
ENS also.
Bailable offense.
Thank you.
Hmm.
Later part.
BNS.
Classification of
Yes, classification, Lordship, let
Okay, now proceed.
here other sections are perhaps available, madam, but here 92, madam.
That is there any ingredients to fulfill 92?
Yes, 20 part is there, madam.
absolutely, Lordship, not,
Demand
it's not
of
there.
money also there. 1 lakh rupees was demanded, and thereafter later part is just kidnapping part.
Yeah.
Later part is just kidnapping.
But it is 72 days in
Yeah,
Fine.
72 days. Even 7 years, Lordship, then will be 60 days.
Part 8. Also, so it's submitted by Mr. Ahmed. That the case has been raised in section 90, section 2, PNS, along with some other section, which are which are available, some of which are available in nature, and is in some of the offenses statutory period of 60 days. But the present petitioner is in custody since 72 days, 72 days, and thus the IR was an opportunity to interrogate him, giving him moreover submitted that all the cases registered under section 90, section 2, PNS, but there is no such ingredients to attract the said section. So considering this aspect of the case vis-a-vis the period of detention already undergone by the petitioner, he may be enlarged on bail. However, petitioner is willing to apply for terms and conditions. Mr. Sharma, the runner is submitted though some of these sections are available, but from the materials in the FIR, is seen that there is a sufficient cruelty. Sufficient cruelty was inflicted on the in the daughter of the informed, and the her child is also been kidnapped by the experts. Accordingly, we insisted all for need to help the case is raised, comma, the ingredients and statement made in the FIR vis-a-vis the period of detention already undergone by the accused petitioner. I find that interpretation may not be necessary for the purpose of okay, you will continue. Can you get up?
Lordship, it's set with CDM South Sonora.
To the subject, see themselves.
Harmless.
Yes.
Harmless. Lordship, in this case, Lordship, FIR has not yet been registered.
Not be raised.
Not been registered. Page 6, Lordship. I kindly note this. Para 7 and 8. This is the circumstance, Lordship. One 6th semester student died on 6/2/2026. and only in the evening of 2/26, his father informed the dean that his son consumed some pesticides on being allegedly scolded by ma'am in the class on 27/1. After 10 days, he died. And after 6-7 days, his father informed, but it was not informed when he consumed this pesticide. Lordship. That is our case is also being narrated in my para 8, Lordship. I'd like to, this is the position, Lordship. I would like to draw your honor's attention to page number 11, Lordship. I'm an assistant professor in the Department of Pharmacy of the Kaziranga University. I'm Masters of Pharmacy. I stood at the first class with distinction, Lordship. From campus, I was selected. Then I'd like to draw your honor's attention to page number 12 and 13. It was my appointment letter 12, Lordship. 13 is my identity card as assistant professor. And Lordship, 16, Lordship, page 16. I was also pursuing PhD in the said Kaziranga University, Lordship. This 16 is the PhD final registration, Lordship. And 17 and 18, Lordship. 17, I was adjust as base teacher, Lordship, by the college as well as by the department as a student, Lordship, Diploma of Pharmacy, second year student. And also they have this 18, Lordship, page 18, Lordship. Page 18, due to my quality and my performance, Lordship, the student also gives me the title as Mrs. Nightingale. I was respected by everyone, Lordship. I am also, Lordship, only 28 years of girl, Lordship, pursuing PhD as well as doing assistant professor. So I am in no way connected. But at this stage, I want only interim protection, Lordship, because I am a girl pursuing a PhD as well as doing working as assistant teacher. And that was an unfortunate incident. We do not know the actual reason. After he has attended lastly only on 27 January, and he died on 6th. And college authority only knew on being informed by his father on 2nd, Lordship. That was the position, Lordship. Now, already college has made an inquiry. This university has made an inquiry. Inquiry is going on, and we hope that we are being informed that every student also doesn't indicate this particular teacher, Lordship, or it was only practical class. There are group of this 25 out of 100, and on that particular day only 4 or 5 persons students were available in the practical class. And in this regard, Lordship, I would like to rely on 3 decisions: one of this court and 2 of the coordinate bench of this court, Lordship, wherein interim protection was given till this calling for a report from the Pulivor PS of Jorhat district, Lordship.
Well, here my first submission is that here FIR part not whether it is FIR was registered or not against her, that is not clear from the petition.
Not at least.
Not at least. Well, then I will have to take instruction from the whether any FIR has been registered against the present petition or. And considering the allegation against her, my objection is that at this stage, it may not be granted, considering the gravity and seriousness of the offense. And I will first take the instruction from the which answers whether any FIR. They have the call for city, and after verifying the city, it may be considered. That is my submission. But one person died, who is also 6th semester, who is a 6th semester, allegation is also that he has scolded disease, that's why he committed suicide. Allegations are serious against her, particular specific allegations against her. My submission is that first of all, I will take instruction regarding any FIR loss. After FIR loss, call for city, after Using the
Okay.
skill of my consider. That is my son.
Lordship, I'd like to add, Lordship, in two cases of the coordinate bench, the even it was not registered, the bail was granted. I am not pressing for bail, Lordship. I'm only pressing for one order I have placed, only submitting this not to pass an order to direct the OC not to take any coercive action till receipt of the report, Lordship. Because of the fact that, Lordship, we do not know anything. And there is no material before this court, Lordship. And the admittedly, boy has attended only on 27. And after 10 days, he died, Lordship. Nobody even, no any allegation was placed before the authority. And even father had also not told the authority that the boy had consumed this poison on 27, 28, 29, 30, 31, 1st of February. Only on second. Yes, certainly. So far, my instruction, I am placing the same before the court. At the same time, we must see the interest of the victim always, Lordship. We could not forget the interest of the victim. At the same time, Lordship, I am a young girl. My interest is also to some extent protected because till now, there is no material against me, Lordship. Because I am a young girl. I am pursuing PhD. I am doing this assistant professor. And the material before the court is that I was judged as best teacher by the authority as well as by the student committee also. The document is there, Lordship. That is why I am only asking that till the report is received, the coercive action may not be taken against me. After receipt of the report or after getting any material, if court pass any order rejecting my bail petition, I have got no objection. That is my humble submission.
No coercive action is similar to the intent.
That is a protection, Lordship. That is the
It's an application for DNS Supreme Court district used to report police station to report police station to on the road the boy could be on 6 to student of 6th semester of the in the Department of Pharmacy. In which college is this? Department of
pharmaceutical.
no, Department of
Pharmacy.
college name of the college is
Lordship.
The D farm, the fees.
Lordship.
Basic.
Department.
Pharmacy in the state. The date of the deceased or about regarding the consumption of any pesticides at school. And it has come to the knowledge of the college authority only on 02/02/26. It's further stated that it is a fact that the boy attended class on 27/01/2026, and since then he was not attending the class, but on that particular day, no serious incident took place in the college. Also, the petitioner is discharging her duty as a assistant professor in the Department of Pharmacy, and at present she is also pursuing her study at PhD. At the same time, she was also awarded with best teacher, and students also appreciated her and gave her title as a knight in her book. Miss Knight. He is not in a position to say as to why the police is searching. However, she is ready to cooperate by Next, Mr. Sharma, the learned person submitted his reply that from the allegation, and from the allegation, it is seen that one student of 6th semester died by consuming pesticides. Pesticides, where the petitioner was also discharged her duty as an assistant. He accordingly submitted that he may take instructions from the concerned police station as to whether any case has been raised by fully board station Jorhat, but no interim should be provided considering the nature of allegation brought against. Next, submission made by non-consequences. The learned action hereby asks to corporate of the take instructions as to whether any case has been registered against the present petitioner pertaining to Pulipur police station, Jorhat, and considering and further considering the submission made by council and the concerned police station is hereby directed not to take any corrosive action. Still receive let the report be called for 9th of March.
Right.
Well, here, Lakshmi can be page 2, my lord. Here is some correcting details necessary for correction, my lord.
Page 2.
2, my lord.
No.
Page 2, my lord. It's son of
Look,
it is daughter of my lord.
I may be allowed to correct.
You cannot be allowed. Then let it be. It should
Lordship,
be
I may be allowed to add this additional evidence.
it's pointed out. It's seen that in the cost title of the petition. She is named as a son of Jitu Bhutia, which ought to have been and the daughter of Jitu. In that next, Mr. Kulla submitted, he may be permitted to add an additional for correction the cost. Estimate accordingly.
Lordship, section 9.3.
9.
May it please your lordship.
Yes.
Lordship, this application has been filed on anticipation of being arrested on a GD entry nil by Jorabad Outpost Police Station under Boost BS. Lordship, first of all, I would like to place page 9 before your lordship for your kind perusal. This is the agreement between the petitioner and a person namely called Shah Alam for purchasing of a flat, 1500 square feet, lordship. This agreement, all the clauses are here. So first clause at page 9, lordship, total consideration is 62 lakhs, with the mutual consent of both parties. Then page number 10, lordship, today first party has received an amount of 10 lakhs, dated so and so 25/8/4/2025 as an advance amount and cash by the second party on the day of execution of this agreement. Remaining balance to be paid by certain date has been given, 24/2025. This was the date fixed, and along with all other this one, lordship. So this agreement was executed between the parties in presence of witness, lordship. Thereafter, lordship, after this payment, lordship, petitioner has paid another amount that I have mentioned at para number 10 of my application. Another 10 lakhs he has paid. So total as of now, he has paid out of this total consideration 20 lakhs, lordship. Thereafter, lordship, may I pray lordship to look at my para 7. That is very important, lordship. Para 7 of the application. That the petitioner begs to state that he has further learned that the Panbari area where the flat is located is currently under a government imposed hold regarding sale and purchase permissions. Consequently, even if the petitioner completes the full payment, the legal possession and sale permission cannot be granted under the current administrative restrictions. So this being the situation, lordship, when petitioner inquired in the feel and found that the Panbari area, sale and purchase has given a temporary ban, Lordship. So he did not pay the rest of the amount as agreed by this agreement. Now, Lordship, this informant here, the Shah Alam, that is the one who's the first party in the agreement, he is at the instant of the police every day visiting petitioners and threatening petitioner to arrest in a case. Even police is also making random visits. So at this stage, Lordship, may I pray, Lordship, that until the information.
You got the GD number?
GD entry nil, Lordship. Petitioner made all endeavor to get the information regarding that. They are neither disclosing, but every day night they are coming to, they are trying to arrest the petitioner, Lordship. That is, Lordship, that is why petitioner.
You are saying that GD entry was there?
Nil. I said GD entry nil, Lordship. Even
it means there is no GD entry.
GD, they are not disclosing anything, nor no FIR, no. They are making attempt to arrest the petitioner. That is the situation, Lordship. So may I pray, Lordship, let them take in instruction. And in the meantime, Lordship, considering the entire fact, Lordship, since a purely case of civil nature, if anything, Lordship, defaulted on my part, the civil forum is always there. They can get the alternate remedy, Lordship, to evict me from the premises. So may I pray that no coercive action be taken until the receipt of that is my prayer, Lordship. Because every day night, police is visiting along with goons, Lordship. They are in a very critical situation, Lordship. Mental trauma.
Perhaps submitting more than that, my lord, police along with goons, my lord. That submission may not be acceptable at this stage, my lord. Police require along with the goons, my lord.
I have placed
Such
actual
type of
fact.
Submission not acceptable here.
I have placed the actual fact. That is the fact.
Let me call for report from the my lord. I will regarding any register. And regarding my lord,
Meanwhile,
it
Lordship.
is at present it is now going to a trend, my lord. If someone call for the my lord, police call, then they wait for intent for
Yes, and there are many methods.
very.
But in the event, Lordship, my fundamental right will be, Lordship, snatched, Lordship.
There may be.
I have expressed my
apprehension, madam. That police may.
Exactly, my Lordship. That is why I have.
Lordship satisfied.
That I have made all statements, Lordship, categorical statement. That is why I am before your Lordship, Lordship. That is why I am before your Lordship.
Realistic. No. On any case, any from a case to be registered in your from print rubber that it enter for sale agreement for sale with one shall supposed to sale contract with the consideration of 60 tax 50,000 paid and it's the other when he came to know that the primary area wherein that is located is currently good regarding the sale and purchase from he did not pay the remaining amount that at present the said and the other party along with said Sahan and the visited and replaced the outbreak setting that the arrest case which to be registered under Panpati Post. From she further stated from the agreement itself, seen that the case of civil dispute. However, petitioner is ready to extend his it is provided with summit. That there is no consider the interim player of the petition. However, he may be called for court to take instruction from the boundary of that the case has been placed. Any GDNT of the case has been placed against the presentation. Committee raised objection in granting any interim till this is hearing the submission made by the considering the nature of petition which may be brought against the petition. The Panpati outpost, police from the Panpati outpost, thereby direct taken prosecution. Done it. Take instructions of the report from Panpati to where the case is based.
Deeply obliged, Lordship. And Lordship, one should be Jorabad outpost, Lordship.
Oh, sorry, Jorabad.
Jorabad.
It affected Jorabad.
I'm highly obliged, Lordship. Highly obliged.
May it please your Lord. Plus a government employee, my Lord. Wife committed suicide, my Lord, after 5 years of divorce, my Lord. Marriage in the year 2015, my Lord. Birth of a girl child in the year 2017. 2019, she filed a case under 498A, my Lord. 2021, divorce was granted as per Muslim law, my Lord. After that, 2026, she committed suicide, my Lord, and they put the allegation on me. Neither instigation nor aided, my Lord, in the offense, my Lord. Page 18, Lordship. FIR is at page 34, my Lord. Before the FIR, Lordship may kindly see two orders, my Lord. One is page 20, my Lord. I was acquitted in the case of the page 20, Lordship.
Yes.
498 case, I was acquitted. Judgment is pronounced in the open court as per judgment of the prosecutor failed to establish case against the accused, so and so, Lordship. And thereafter, page number. Marriage was dissolved, Lordship. That is at page number 20 and 30, my Lord. Marriage was dissolved in the year 2021, my Lord. Page 30. As per Muslim law. FIR is at page 34, Lord.
Marriage dissolved in 2021.
21, my Lord. Marriage was dissolved. From 2019, there is no relation. That is reflected in the FIR also, my Lord. Page 34 is the FIR. With due respect, I beg to state that 10 years ago, my sister so-and-so was married to the below mentioned accused person as per Surat law. They started life together and through their bedrock, a girl child is born. Her current age is 8 years. After the marriage, in the context of demanding dowry, the accused petitioner used to mentally and physically harass her. On so-and-so, the accused person caused grievous hurt to my sister, and in this regard, an azhar was lodged in the Gosaigaon PS 2019. And the police rescued my sister from the accused person. The accused person, despite having my sister solemnize another marriage on 12/12/2025, without taking a divorce, my sister, unable to bear the harassment of the accused, has been living with us since last 6 years. And her daughter is also lives with us. Knowing about the marriage of the accused person to another woman, my sister mentally broke down on so and so at around so and so committed suicide. So neither aided nor abetted me, Lord. 10 years of separate. 2019, we have been separated, living separately. 21 divorce was granted. All I know, Lordship, that her parents died, Lord, recently, and because of family dispute, this has happened all. Now they are making me a scapegoat, my lord, in the matter. I'm a government employee, lordship. Can see page 18, my lord, working in the health department, lordship. Page 18 is my ID card, my lord. But this is kindly
If
protect.
you're government, how can you marry without getting the divorce?
You're not married, my lord. This is only an allegation, lordship. And second thing, lordship, there is divorce, my lord, page 21. We have taken a divorce, lordship. You can see, my lord, page 21. Sorry, page number 30, lordship. They registered divorce, my lord. I got a 2021 divorce, my lord. The marriage separation was registered in my presence in the police. Kaji and register Muslim marriage and divorce, my lord. So already divorced, my lord. From 2019, no relationship, my lord. And for section 45, lord, I have to aid abet, my lord. There is nothing of that sort that has been reflected in the FIR itself, my lord. Basically, no case, my lord. But because it is, I am a government employee, if I am arrested, my lord, I will lose my job. So I have to come with him, with the FIR. Yes, my lord.
The FIR itself, my lord, from page 37, my lord, because allegation earlier it was that demanded some dowry, my lord. বিভিন্ন ধরনের যৌতুক দাবী কৰে আৰু শাৰীৰিক মানসিক অত্যাচাৰ চৌবিশ তাৰিখে মোৰ বাইদেউ আছামীজনে মাৰধৰ কৰাৰ ফলত গুৰুতৰ জখমপ্ৰাপ্ত হয়।
And get booked. You'll be under interim protection. Which date?
My lord, 19th of
19?
March.
I'm of this.
Yeah, please, Lordship. My lord, in this petition, my lord, I have challenged my lord, the order of framing of SARS, my lord.
Oh, 9.
Because my lord, SARS has been framed, my lord. And in the my lord, SARS frame order, there is, my lord,
Challenging the framing of charge.
technical, my lord, error is there, my lord. Because kindly turn to
Technical
case.
error?
Yes, my lord, turn to page 29, my lord. Because my lord, SARS has been framed under the offense of cheating and my lord, criminal breach of trust. My lord, both cannot be coexist on the same allegation, my lord. Page 29, my lord.
So have you filed any petition for your paying for your teachers at the time of hearing of consideration?
No, my lord. I am seeking not for discharge, my lord, but my lord, SARS has been framed under two sections, my lord, earlier 420 and 406. My lord. So both cannot be coexist on the same allegation. I have annexed the judgment, my lord. Kindly
What
turn
is
to
your
case.
prayer here in this case?
Prayer, my lord, appropriate, my lord. SARS framing may be framed under appropriate section, my lord.
How it will harm you?
Because my lord.
Now see, I can understand your submission that
Yes, my lord.
cheating and the criminal breach of trust cannot go together.
My lord.
Rightly submitted.
My lord.
I can understand. So what prejudice will cause to you?
Because it will be, my lord, abuse of process of law, my lord. Because it is against law, my lord. Kindly turn to case 21, my lord. Judgment, my lord, kindly see, my lord. So it is against law, my lord.
No, I can understand. But at this stage, what will be your prejudice will cause to you? Is there any? I mean, suppose definitely at the time of suppose you are being convicted. Any in that case also you cannot be convicted under these two sections together.
My lord. But when my lord SARS is framed, my lord, under two sections, my lord, I may be convicted also, my lord.
Help you later on. If it is suppose defective charge, it will help you later on also. It may be
but when my lord SARS
for your even for your acquittal or at the time of appeal also. Suppose if you can.
But my lord, when SARS is framed, my lord, already under two sections, my lord,
that's what I'm saying. If it is a defective charge, it will help you rather.
My lord.
In the long run, it will help you. Suppose if it is a defective charge on that ground also, it may be a case. I don't know. If you got convicted, and that may be a case for even for consideration, even for acquittal, even for appeal.
My lord. But if it is allowed, my lord, to go to it is allowed to be continue the trial, my lord, but it will be a process of law, my lord.
Or the abuse of process of law. What do you submit?
Person that is to lordship because lordship at this stage yes, two charges has been two sections has been incorporated in charge
It
limit.
is a very
That is
defective
different
charge
also
only,
because
that
lordship,
much.
while trial is going on, the automatically birth section will attract that will be remain and another will go lordship. And
Because
even
sometimes it
if they are
happens that
paying
in 302 also. 302 is there, even 304B is also there, because alternative has to be there.
maybe
There are some reasons are
and
there.
if at this stage lordship they are paying for passing of that charges all charges, if prior to that they will file a application before that lordship, before the trial court for discharge of charges lordship. Prior to that lordship they have to file application before that real lordship. And charge can be altered at any time lordship. It's not that
Yes, yes,
at any time lordship, because 1-2 charges are there. Whatever charges attracted, that will be given. Sometimes in most of the cases also we have seen also 376 is also there. POCSO is also there also. They are not court is not court never punish one person in two sections also. When attracts after the trial also, during the course of trial what comes, that will be attracted also. They will not be there. There is no any abuse of process. It is not that lordship that section 4 regarding section sitting a separate trial will go. Thereafter section Bishop plus separate will go. Then it will be a bishop process, it may be lordship. So it will go run at the same time lordship.
But charge cannot be framed under these two sections simultaneously.
That's what I'm saying. It is a defective charge for you. I can
So,
understand. And Mr. Locker is also admitting it, that
So,
the fact that it is a defective.
on the basis of
What
defective charge,
it is
if it is
defective
allowed
to
to
you?
continue, my lord, if it, definitely, my lord, it will abuse of process of law, my lord.
Yes, what to do? We cannot directly court to frame this charge under this section or
What
that
sections
section.
are
That cannot be
attracting?
done by this court at this.
What sections are attracting? We do not know. Lordship.
We do not know now. At present, we do not.
At best, they can file an application for proper incorporation of sections lordship. That application they may file before the trial court lordship. And
Now, prima facie, at this stage, you are not being prejudiced by any defective charge. Rather, it may help you. I'm just saying, it may help you in the long run. Now, question is that even if suppose if it is defective, you want to, because we are not the court supposed to make direction to the learned trial court below the frame charge in the on this section. It cannot be.
When, my lord, on the face of the record, my
Your
lord,
prayer now.
when, my lord, some technical error is there, my lord, your lordship can call for the records under revisional power, my lord.
What is it?
May I, Lord?
Yes.
In BNS and double A, 512, there is clearly stated that no finding, sentence, or order of a court of competent jurisdiction or on the ground of any error, omission, or irregularity in the search, including any misjoinder of searches, unless in the opinion of the court of appeal confirmation or revision in a failure of justice has been in fact there. So it doesn't matter.
It's what I'm saying.
Unless
That's what I prima facie, if you see there is no such kind of prejudice caused to him at this stage. That's what. And as Mr. Locker is submitted that he can approach the court below that it is a defective charge. So maybe further hearing on charge.
My lord.
Modify. But we are not the court that you frame charge under this section. We cannot say at this stage. How can we say?
in each and every petition, if I could interpret then.
It will be very limited.
And liberty may be given to my lord approach before the landed court below for my lord alteration of charge, my lord.
They can file appropriate application for alteration of charge, and that will be passed as per law, as per.
Trial court will be. If it is suppose in your case it is a defective. Or Mr. S.H. Sitter. You pointed out which section? 510. 500. This is an application section 38 PNSS. Against the implement order it is 1610 passed by learned SDGM M in charge. Not like SDGM M. In PRC case number 83 of 25, where the charges framed against the present petitioner under section 316 of subsection 5 and 318 section 4 of PNS. the basic contention of the present petition is that the court, the charge which has been framed by the learned trial court below on 16. Your NXG order in which page?
Case 29.
29. 29. Framed on 16/10/2025 is a defective one as the charges under which one is criminal breach? 1316
My lord.
and 318 is cheating. No?
Cheating.
Subject that both the sections cannot be attracted against one person at the same time as the section 316 is of criminal breach of trust. On the other hand, 3182 BNS is of cheating. It is stated that if there is any allegation of misappropriation of money, it cannot attract the section money, it cannot attract both the sections together as 3162 public 3182 BNS, under which the charges has been framed against the present petition. Accordingly, it is submitted that the charges which has been framed is a defective one, and for framing of such defective charge, there will be abuse of process, and in that case, the petitioner will also be prejudiced. Accordingly, this by the instant petition, he prayed for setting aside and quashing of the order dated 6/10/2025, under which the charges against the present petitioner was framed by the learned trial court below under section 3165 of the 3184 BNS. Next, Mr. Crawford, the learned petitioner PP, submitted with this regard that even if there is a defect in the framing of charge, that cannot cause any prejudice to the present petitioner, and he will get ample opportunity to contest it, and that part may also back petition for modification or alteration of charge before the learned trial. He further submitted that as per section 510 BNSS, also the 510 BNSS speaks as under in view of this submitted that the present petition is may be disposed of with a further direction to the petition to open application before the learned. Next, hearing submission made by the case recorded the order passed by the learned SDGM S Mukakat in PRC case number 83 of 2025, whereby the charges were framed against the present petition under section 3165 and 318 BNS. Without perusal of the other matters on the record, this court is not in a position as to which section would attract against the present petition. However, it is a fact that, however, there may be some defect in framing the charges against the present petition as it is as submitted by the learned counsel for the petition, that both the criminal breach of trust and the offense of criminal breach of trust and cheating cannot run together. But this court cannot direct the learned trial court below to frame charged under any particular sections without prejudice of case record. And in the same time, it is also seen that there may not be any prejudice caused to the petitioner, even if there is any defect in the charges, trimming of charges. However, petitioner is at liberty to move an application before the learned trial court with a prayer for alteration, the modification of the charge framed against, which may be considered by the learned trial court if it is found necessary. With the above observation, the present petition stands dismissed. Okay, we made a direction.
Hello.
Please, your lordship, I'm the petitioner of the instant petition, lordship, and I'm married to the respondent, lordship, 10/3 in 2022, lordship. And lordship, it's a matrimonial dispute, lordship, for which I left the matrimonial home, and I have filed 2 cases against the respondent.
Petitioner, which is related to that offense against woman, promise to marry and rape, and his 2 accounts were defreezed, one loan account, one salary account, and subsequently the loan account was defreezed, and salary account, lordship may kindly come to page 53, relief and person, it was observed that salary account of the accused
What is page number?
Page 53, paragraph 3,
Yes.
The salary account of the accused shall remain freeze until completion of the investigation. So, the offense was neither related to any economic offense or any offense against property. On the last occasion, my learned friend was directed to obtain instruction.
Sheet submitted,
Submitted. And perhaps
so Sarshit has submitted, and it is also stated there, lordship, the salary account of shall remain freezed until completion of the investigation.
So investigation is complete as of now,
No, but at this stage, do you know about anything?
Yes,
Or what I'm saying, that case has already been charged as per his instruction.
Yes.
So you can very well approach before the learned trial court below with an appropriate application. I don't know at this stage whether it has been defreezed or not.
No, not defreezed. Not defreezed.
Not yet defreezed.
Yes. So there shall not be any impediment now, my lord. My learned friend may also may not object to that effect.
Because and one report is also there. He has stated at this stage won't affect the investigation of the case.
Yes.
Defreezing. But why it was defreezing? If you're saying that
yes, that is what, my lord. Yes, kindly see, my lord.
Under which section case is registered?
Under section, my lord, case was registered under section 3162, 3184, 64, 3512 of BNS.
That is how it is woman related 316?
3162. 3184. And 64. And 3512 BNS. That is what my lord learned CJM observed. Lordship may kindly come to page 52. Paragraph 2, my lord. The case is relating to alleged rape on the victim by the accused. Generally, bank accounts have nothing to do with the allegation of rape. Rape is an offense against the woman where the accused establishes physical relationship with the victim without her consent. Freezing of bank account is necessary in an offense which falls under the category offense against property. The investigating officer apprehends that if the accused can access to his salary account, there is likelihood of influencing or intimidating the witnesses by him. There may be substance in the apprehension of the investigating officer, but I respectfully disagree with the view taken by the investigating officer. The accused is on bail and he has not violated the condition of the bail. The humble view of this court is that an accused is presumed to be innocent until proven guilty, and he has every right to being a citizen of India as guaranteed by the Constitution of India. Freezing of bank accounts amounts to infringement of right to property, which is valuable constitutional right. So it was already observed. But considering that he may influence like witness by that amount, that was kept freeze till completion of the investigation. Now, my lord, he has observed, he has Yes,
So next para is defreezing the bank account of accused immediately being the account number so and so, which
yes,
is
that
not
is the loan
salary
account. That is the loan account.
Loan account.
Loan account has already been defreezed. Now, IO has stated that there will be, he will have no objection if his account is defreezed. So Lordship may pass no necessary order.
From here saying that till
It is in the
Next para.
third para, Lordship, 53.
no, it is defreezed
Lordship.
as a completion of.
Completion of the investigation. It
Now
will
what
be
is the
freezed
report
until
of the
that
IO
period.
says?
IO in the charge sheet submitted, Lordship. And therefore, defreezing of the salary account of the accused to ensure, Lordship, at this stage won't affect the investigation.
But Mr. N.K. Kalita did an account of but Mr. K.K. Das did an additional PP appearing on this application. Section BNS related section. Yes. Everybody, prayer for watching the order CGM Bulak India case number 9591 arising out of Numligor Rural PS case number 98 of 25, whereby the prayer for the petition for defraying the low account is allowed and prayer for defraying the salary account was the 1/12/25 order is at page
Miller.
31/12/2025. The order which have been challenged. The 1/12. It is.
Yes, that is the order impugned, Miller. It starts from 51.
31. Yes, I have.
Yes.
Next, submitted that during the inspection of this case, considering the prayer made by the loan of the present petitioner as well as the salary account was freezed by the trial court below. However, after on considering the prayer of the present petitioner, the learned CGM had decreased the loan account of the petitioner by its order dated 31/12/2025, 25, which with the observation that the case is indicated it is the case where the allegation of rape has been brought and the rape has been brought, and hence there is no necessity for freezing the accounts of the present petition, and it is not related to any offense of, against any property. But in spite of the said observation, the salary account of the present petitioner is still freezed with a direction with a direction for freezing his salary account till completion of the investigation. But at this stage, the case has already been the investigation has already been completed, and accordingly, it submitted that this case is not an economic offense nor related with any property, and hence paid for defreezing his salary. Next, Mr. Sharma, the learned for Mr. Das, the learned additional PP submitted in this regard that had order dated 31/12/2025. His salary account was freezed till completion of the investigation. But at this stage, the case has already been charged sheeted. And for the note of the IO, it is stated that defreezing the salary account of the present petitioner will also not affect the case at this stage, as the investigation is already over. The case has already been charged. Such a number is
It is 06/2026 under section Lordship 316 with the 2 within bracket Lordship 351 plus 2 6481 and dated Lordship 11/02/2026.
Next, during the submission made by the it is seen that during the period of investigation, both the loan account and the salary account of the present petition was freezed, with considering the prayer of the I. However, on the petition filed by the present petitioner, the learned CGM Gulak had freezed the loan account of the present petitioner with an obligation that case is related with the offense against a book and not against any property. Further, from the trial itself, it is seen that it is not a case against any property or not in an economic offense. But while freezing the loan account, it was observed by the learned trial court below, considering the learned trial court below, that freezing of the salary account may be required till completion of the investigation, as it was submitted by the IO that he may hamper or tamper with the witnesses if his salary account is not freezed during investigation. But from the submission made by learned counsel, learned additional people, and from the report of the IO, it is seen that case has already been charged. Completion of the investigation and investigation more so, considering the nature of allegation brought against the present petition. This court is of opinion that freezing of the salary account of the present petitioner is not required at all, not required at this stage, and hence it is hereby directed to learned trial court below pass necessary order in defreezing the accordingly it is court the opinion that the salary account of the present petitioner can be defreezed, and in view of this, the learned trial court below is hereby directed pass necessary instructions, public directions to the concerned bank authority or to take necessary steps in defreezing the salary account of the present petitioner. Can you tell us the salary account number?
Account number in prayer person, it is there, madam.
In the prayer.
In the prayer, it is there. Page 13, madam.
Salary account number 11288863230. First, vertically silo. I have seen numbers. It is of which bank it is?
Now, madam, it is
SBI.
transferred to Dispur branch.
No, otherwise it is SBI account.
SBI.
Okay, SBI.
Object.
This
May I please, your lordship? Lordship, this revision is challenging the impugned judgment and order dated 4/11/2025 passed by the learned court of session judge lordship, Golaghat, whereby the learned appellate court dismissed the appeal referred against the acquittal order passed by the learned JMFC Golaghat lordship.
Order of acquittal.
Yes, lordship. Lordship, the brief take of the matter is that an FIR was lodged on 14/12/2018, lordship. FIR is in page number 17, lordship. May I read, lordship? That FIR is lodged by the present petitioner, lordship, pursuant to my FIR dated 9/12/18 under reference number so and so. filed at NRL Police Outpost. This is to inform you that today at around 10 a.m., one Ankur Dev Soikia, son of late Gunin Soikia, resident village Habisua, post office Sinatoli so without authority, illegally trespass into Section 5 of Bogi Division of Bogidhola Tea Estate, instigating the culprits whose name have been mentioned in various FIRs filed earlier to cut tea bushes, conspiring to usurp the Bogidhola Tea Estate by causing irreparable and immense damage to the company properties, lordship. And during the trial, lordship, prosecution side examined 5 witnesses, lordship, including.
Okay, this will come later on. Now your question is that this person got acquitted.
Yes, lordship. At this stage, lordship, notice may be issued.
You have to issue notice at
Yes.
this stage because
And-
the case against acquittal, na? That's right. The state is a party here.
Yeah, partners.
This year also will be good.
Yes.
Yes, this year will be required. Who got acquitted? That Ankur Dev Saikya.
Yes. Respondent number 2. All the prosecution witnesses without any contradiction, lordship, depose about the incident and presence of respondent number 2, lordship. But the court has erroneously came at a finding that all the witnesses are supporting witnesses and they are the yes attesting witnesses, lordship. And there was no independent witness was examined, lordship.
You are MS?
Yes,
Your good name? Your
K.
good name?
Bharali, lordship.
K. Bharali.
K. Bharali.
MS K. Bharali. Item number 13. There are constitution also to be a state respondent. This I have section 4 related section 438 of BNS against the impugned judgment and order dated 4/11/2025 passed by the Net Court of Session Judge at Golaghat in criminal appeal number 05 of 2023, whereby the learned court had dismissed appeal filed against the impugned judgment and order dated 2010/2022 as by learned judicial JMFC Golaghat in GR case number 2598 of 2018, acquitting the accused respondent from the case. Issue notice to the respondents through speed post and usual process. No formal notice is required to be served on state respondent number 1. The copy of the petition may be served during court sitting. Also calls for the scanned copy of the TCR, Twitter TCR for accordingly after 2 weeks, 4 weeks, 4 weeks as an intake. You take steps.
Much obliged, lordship.
Please call for the
This year.
Okay.
Please, Your Lordship. Lordship, impugned order is at page 42, Lordship, wherein the petitioner was marked absent, Lordship, and bailable warrant of arrest was issued, and defense plea was also closed, Lordship. Lordship, on that date.
14.
Item 14.
No, page number?
Page number 42.
40.
Bailable warrant was issued against the accused petitioner, Lordship, and defense plea was closed, Lordship. Lordship may kindly come to page 38. On that day, she was present personally before the court. The accused petitioner was present personally before the court and filed a petition, Lordship, at page 38, Lordship. 38, 39, Lordship. Page 39, Lordship, prayer to allow the accused side to cross-examine the complainant and further be pleased to defer the stage of defense evidence, defense plea till cross-examination is completed, Lordship. And that was duly notarized, Lordship, before the notary public at page 40, Lordship, the affidavit, Lordship. Page 40, Lordship. That was not taken into consideration, Lordship, not entertained, Lordship. Page 41 is the Hajira, Lordship. I've enclosed the Hajira. That was also not accepted, Lordship. And thereafter, bailable warrant was issued and defense plea was closed, Lordship. On 38, and I.
Can dispose of it.
Yes, Lordship may dispose it and direct me to file my defense plea, Lordship. Otherwise, I would not be allowed to rebut my case, Lordship. The allegations that are leveled against the accused petitioner.
That day it was
Fixed for defense plea, Lordship.
defense plea.
Defense plea or stroke defense evidence.
Then why this case fixed is on 12-2 for appearance oblique cross of PW1?
Because warrant was issued, Lordship. That is why on 12-2 it was fixed for
No, I can see.
appearance. And,
Now, but the question is that in Annexure 9, that is a page 38, this is an application praying for allowing the accused to side to cross-examine PW1.
Because no date was fixed for cross-examination, I prayed for allowing the accused side to cross-examine before the defense plea is submitted, Lordship. That was not entertained, not accepted, Hajira not accepted. Thereafter, this order was passed, Lordship. But basically, Lordship, in summary trial cases, Lordship, once defense plea is not not allowed to be filed, Lordship, then summarily the court may proceed, Lordship. Otherwise, I will, if I fail to submit my defense plea, Lordship, I may not be allowed to rebut the allegations that are leveled against the accused petitioner, Lordship, and I may fail in the case, Lordship.
No, but this case is registered under which section? In fact,
NICR, Lordship, Negotiable Instruments Act.
Oh, NI.
Yes, Lordship. A small plea, Lordship, I may be allowed to file my defense plea, Lordship, by setting aside this order, Lordship.
So this is your prayer.
This is my prayer, Lordship. Prayer portion is at page 11, Lordship.
So before completion of the prosecution witness, how can you file your defense evidence?
That is the procedure that is going on, Lordship. I don't know because before
defense plea is okay, but defense evidence how?
Defense plea, Lordship, in the e-court services, it is shown as defense evidence, Lordship. That is why I have stated in my
plea may be there,
defense plea oblique defense evidence, Lordship. That is why I have stated everywhere defense plea oblique defense evidence.
Defense plea on defense
Defense,
evidence.
yes, I have stated that is what. I've stated in somewhere in my petition, Lordship.
This order is of 20/01/2020. Prior to that, what is the order?
Lordship, 12-2, it was fixed for appeal.
No, that was subsequent date. Prior to the 20/01/2020.
Yes, there I have enclosed the orders, Lordship.
You have not enclosed yet.
Yes, I have enclosed. Page 35, Lordship.
Page 35.
Yes. It was fixed for defense plea, Lordship. Page 35 is the type copy, Lordship. Page 35.
It was fixed for defense plea.
Defense plea, Lordship. Because, Lordship, talk of settlement was in the meantime going on. That is why the court said they let that matter be fixed for defense plea. In the meantime, if something happens, that would be taken into consideration. But since nothing material is, Lordship, that is why I filed the petition on 21/2026.
Your direction was given to you that you shall be remain present in person.
Yes, I was present, Lordship. That is why I filed the petition, Lordship. I was present. Hajira is there, Lordship, at page 41, Lordship. Signature of the accused is there, Lordship. And it is not the case that the petition or the Hajira was filed in the later hours, Lordship. That is was first case that was taken by the learned trial court, Lordship. I was present. My signatures are there. In the Hajira, Lordship, accused signature is there. In the petition that is there. She was present, Lordship. In the affidavit sworn before the notary public, Lordship, date is there. Small issue, Lordship.
Heard Mr. P. Mujumdar, the learned counsel. Also heard. You are a formal party, state.
Lordship?
State is a formal party. I think.
Yes, yes, yes.
And
Respond
also
number
heard
1.
Mr. P. S. Support, the learned additional PP, appearing on behalf of state respondent. This is an application. Section 5. 438 BNSS against the impute order dated 20/01/2026 plus 5. Learned JMFC Bongaigaon in NICR case number 153 of 2024, wherein the PWA rupees 8,000 was issued against the present petitioner, and defense plea of the defense evidence of the petitioner was dispensed with and closed. Dispensed with public closed. Next, right, is submitted by Mr. Mujumdar that on the earlier occasion, the accused, that is on 4/12/2025, the accused petitioner was very much present in the case, and considering his presence, the name it was fixed on 20/01/2026 for defense plea. With a further direction to appear personally before the learned trial court bill. In pursuant to the said order, the petitioner was present physically before the court on 20/01/2026, file Hazira, and also filed a petition seeking further time for filing his defense plea and to cross-examine.
For cross-examination and for further deferment of defense plea till.
But why you did not pray for it? You are filing your.
No, Lordship. I was not allowed to file any adjournment petition also, Lordship. Directly that order was passed. It was.
No. You have say you were saying that you were physically present on that day, file Hazira, and one petition was also filed by you.
Yes.
But your petition is seeking time for cross-examining the PW.
And further deferment of defense plea, Lordship. At page 39, Lordship. It is there. Page 39, prayer is there. And further, be pleased to defer the stage of defense evidence of defense plea till the cross-examination is completed, Lordship.
Till the cross-examination is completed.
Completed.
Then what is the case?
Lordship, I pray for allowing the petitioner side us to cross-examine the complainant, Lordship, prior to the defense submission of defense evidence, Lordship. Public defense plea, Lordship. That was not entertained, Lordship. Could have that learned trial court could have taken my petition into consideration, thereafter rejected it, or passed any appropriate order, Lordship. That was not taken. That was not considered, Lordship. That is my prayer, Lordship. And marking me absent, Lordship, even though I was personally present inside the court. I was present. Hazira is there, Lordship. I was standing there.
The last one. Filing their defense plea and to allow him to cross-examine the PW1. But in spite of the said petition was also notarized by the petitioner. But in spite of filing of the Hazira and the petition, that was not entertained by the court, and he was and his presence and her presence was also not considered with a direction and passed the order with a direction for issue of BWA rupees 8,000 and closing the defense plea. The case was fixed for appearance and cross of BW1. He further submitted that the petitioner was very much present on the day in pursuant to the order dated 4/12/2025 with the petition, but her petition as well as the her presence was her or him. Her presence and her presence as well as the petition was not considered by the learned trial. However, most of the petitioner is still ready and willing to submit her defense plea and also willing to cross-examine the PWs. If he is not allowed to to file to submit his defense plea as well as to cross-examine the PW. She will be in a very inconvenient position, rather will cause prejudice to her. Next paragraph. Considering this submission made by learned counsel for both sides, I have also perused the case record and the orders annexures filed along with it. This is the fact that on the prior occasion, that is on 4/12/2025, initially an order was passed for issuance of BWA of rupees 8,000, and the case was fixed for 20/01/2026 for appearance report as well as the defense plea. But subsequently the petitioner appeared and her petition was accepted, and the case was accordingly fixed for the defense plea. But it is seen that but from the record it is seen that on the next day, that is on 20/01/2026, also the petitioner seems to be present in the court today with a hazira and a petition seeking further time for her defense plea as well as to cross-examine the PW. The court, those petitions and the hazira may not be placed before the court, or inadvertently the order may be passed without accepting the hazira as well as without accepting the presence of the present accused petition. But prima facie, but from the record it is seen that she was present by filing her hazira as well as the petition, which was also notarized on 20/01/2026. So considering all these aspects of the case, the order dated 20/01/2026 is hereby set aside and paused with a direction to the learned trial court below, give an opportunity to the present petition to file her defense plea and also to cross-examine the PWs. The petitioner will accordingly appear before the learned trial court below as on a date to be fixed. When the next date is,
24/04/2026.
On the next date of listing, that is on 24/04. Further, the petitioner is hereby directed to submit her defense plea and to cross-examine the PW1 without any further action. In view of this, the present supposed to be.
Lordship, on the next date fixed, I shall file my defense.
Yes, you can file.
Oblige, Lord.
Yeah, please, Your Lordship. My lord, I was convicted under section 138 Act, my lord. 4 months, my lord, and compensation rupees 1,36,700, my lord. I have been taken in custody already, my lord.
Really?
Yes, my lord. So, my lord, notice may go at this stage, my lord, and the.
Why you are so late? You are taken into custody.
My lord.
You are late in filing this.
No, my lord. Because, my lord, we applied, we filed a petition before the landed trial court, my lord, for seeking time to file, my lord, appeal, my lord, and I was allowed to. I, my lord, filed petition for allowing me to remain on previous bail, my lord, but my prayer was rejected. I was taken in custody. So the record may be called for, my lord, and.
Mr. S.H. Sikdar, the learned counsel for the petitioner. It's an application under section 442 BNSS against the impugn, which has been dated 29/01/2026, as by learned additional session judge in Sutia in criminal appeal number 17/3 of 2020, upholding the judgment and order dated 18/06/2024 as by the learned CGM Tinsukia in NI case number 79 of 2020. Issue notice to the sole respondents respondent to speed post and judicial process, and also call for the DCM. Let the matter be accordingly listed. Otherwise, your conviction term is for 4 months.
4 months, my lord. And I have filed one IM.
And we can list it after 2 weeks.
My lord, but I may be disposed of, my lord, because I am in custody, my lord. So sentence may be suspended, my lord.
To 4 weeks go after 4 weeks main application. I to Mr. So-and-so, the Lieutenant Counsel so-and-so. This is an application. The section 430 BNSS for suspension of sentence and granting bail to the applicant petitioner during dependency of the instant criminal. It is submitted by Mr. Sikdar that he, after the impugned judgment dated 29/01/2026, as by learned additional session judge Tinsukia, criminal appeal number 17/3 2024. He applied to remain on previous bail before the learned CGM Tinsukia, but that petition was rejected and the petitioner is in custody at this stage. Accordingly, he submitted that till the disposal of connected revision petition, the petitioner may be allowed to go on bail, and by suspending the sentence imposed on him by the above referred judgment. And considering this submission made by the counsel, the petitioner is the execution of sentence passed in criminal appeal number 17/3 2024, dated 29/01/2026, upholding the judgment and order dated 18/06/2024, is hereby state oblique suspended till the disposal of the connected revision petition, and petitioner is also hereby allowed to go on bail for rupees 20,000 with one security of likeness to the satisfaction the learned CGM Tinsukia in connection with NI case number 79 of the after the compliance of the order, with the above observation, the present IA stands disposed of. However, the petitioner is hereby directed to submit the compliance report before the court on the next day. Okay, you are allowed to go on bail of 20,000 with one seat.
My lord. My lord, item 16 also, my lord, same parties, my lord, but sentence is different, my lord. Here 6 months and 4 lakhs compensation. Same, my lord, same party, same dispute. Because 2 cases were there, my lord. So same order maybe.
Party is different.
No different, not my lord, same, my lord. Bolin Moran.
No, 16.
16.
15 is who is 15? It's Messrs. MP Enterprises.
My lord.
And your 16 is Bolin Moran.
Bolin Moran also, my lord. Here also Bolin Moran, my lord. Because that was partnership deed, my lord. I was one of the partners. So same dispute. Here, my lord, opposite party Mohendra Sureka. Here also, my lord. In item number 15, Bolin Moran is my lord, petition number 2, because it was represented one partnership deed, my lord, was there. Same, my lord.
So you are 2, na? Petition number.
Yes, ma'am.
Go to record us. That petition number 2 will appeal to karne like kuliko na like. One revision to tikun na like kali I to 0 petition number 2. Aru 16 to.
Here, my sentence.
16 is filed by directly Boran Valari. This enterprise is not made party here.
Yes, madam. He was made party personally. Bolin Mora. So here, my lord, 6 month conviction.
No, this is here. Bolin Moran is directly a petition.
Yes, my lord. Yes.
He is not through any enterprise.
No, my lord.
But why? If he is associated with the they said
But-
enterprises under which he
But by name, my lord,
his case
should
was
check,
there.
my lord. Yes.
I got to petition number 2 or next same petition. Okay.
My lord. I know.
Conviction term to all of Billy side.
May I please, your lordship, my lord, it is for Jimma, my lord. For Jimma, my lord. Because my actually, my lord, accident case, my lord, but it has been given criminal color, my lord. And alleged incident, my lord, on 8 my lord, 8 January, my lord, and my vehicle was seized, my lord, on 14, my lord. Kindly see, my lord. FIR, my lord, case 14, my lord. FIR
It's an accident case.
Yes, my lord. Actually, accident case, my lord. Kindly see the FIR, my lord, page 14.
There are some other allegations are also there.
My lord.
I don't know. Other allegations are also there. Alcohol bottle.
My lord, but kindly see, my lord, police came. They found alcohol bottles in their vehicle. But my lord, police did not caught us, my lord. Did not take us to police station, my lord, on 8, my lord.
The accident case. I don't know.
No. But my lord, kindly see the seizure list, my lord. Kindly see, my lord. Seizure was made on 14, my lord. Not on the same, my lord, time, my lord. Because, my lord, police came on the place of incident, my lord, immediately, my lord. But they did not, my lord, take us to police custody and police station, and also, my lord, did not.
Before the learned court below.
My lord.
Have you filed any petition before?
Yes, my lord. Yes, yes, my lord. Page 29. After 5, my lord,
So
7
there
days.
some objection raised by the IO.
Yes, my lord. Nothing, my lord. Why, my lord, this objection was made, I don't know, my lord. But clear, my lord. In the, my lord, affair, it is clear on.
Being the CD or
CD will be required here.
CD or a report will be required.
Because, my lord, kindly see the affair, my lord, itself, ma'am. Why, my lord, my vehicle, my lord, unnecessarily, my lord, it is detaining, my lord. For more than 1 month, my lord.
Cannot say now.
Even police did not take our vehicle to.
Like a security done a call for the report from the concerned in investigating officer as to whether the vehicle can be given GP at this stage. Mr. Rocker will put in it. Procuring the report from the.
My lord, on 19, my lord, another intercepted bail petition is pending, my lord. On 19, my lord. Yes, yes.
Tomorrow.
Yes, madam.
Not at all possible.
Another bail application is pending.
We cannot. Because the report from the. Maybe on which date?
27 or 25.
I'm sorry, date, my lord.
27.
27 and 20.
Or
25.
27. 27. There are many matters already been fixed. 27 to realistic.
Oblast.
26.
May it please before your lordship. Lordship, I'd like to bring your kind attention to page number 14 and 15 of the petition, lordship. That is the complaint petition filed by the complainant in the instant complaint case that has been pending in the additional court of CJM, Golaghat, lordship. Lordship, the complainant, herein the respondent and I were in a love relationship for 4 years, lordship. And eventually our engagement took place in presence of our family members.
Fixed on 23rd, no, 23rd. 23rd, 24th, 23rd. So, my lord, my submission is that, my lord, as per your direction, lordship's direction, my lord, the witnesses, vital witnesses, which my learned friend was relying, my lord, those has been examined. And in fact, my lord, there is nothing on record. I have annexed their witnesses, my lord, evidences. They have not said anything against the petitioner, nor they have said that, my lord, the petitioner tried to, my lord, hamper or temper anyway their witnesses. So there is nothing on record. I have annexed the, my lord, witnesses here in the debate petition, my lord. So, my lord, my prayer is, my lord, already 3 years, my lord, 7 months, 18 days, the person is behind the bar. So 1,328 days, my lord. So, my lord, and another here about 40 witnesses are to be examined. 42 witnesses as on today, 42, no, 40, 45,
Who are the listed?
43. 43 witnesses have been examined.
No. Listed witnesses are 43.
95, 96.
96.
So 43 has been examined as on today, my lord. Depositions are there, my lord. Deposition, I don't want to go on merit. The deposition they have not implicated single line, some 1-2 lines. Apart from them, most of them have said we don't know anything about the incident, how it has occurred. That is their witnesses, and they have not said anything against the petitioner that, my lord, he tried to influence them. There is nothing as suspect. So my prayer at this is this, my lord, because the person is more than, my lord, 3 years, 7 years, 18 days. I'm not on merit, because merit, your lordship has seen number 2 occasions, in fact. So on the limited ground, my lord, because if, my lord, the prosecution succeeds, definitely he will have to go for, my lord, conviction. If, my lord, the fails, my lord, the right of the person will be, my lord, he will be separated, because he has small son, my lord, who is now, my lord, at that time he was 2.5 years. Now he is about 5 years, and, my lord, wife. Only those there. So considering all this aspect, only on that aspect, my lord, probably my learned friend may not also object on that, my lord.
May it please your lordship. May I take your lordship to page number 216 of the bill application. The internal page is page number 5. Para 13. To 16 of the bill rejection order that we have annexed.
Yes.
Paragraph 13. I have submitted this way. Mr. Hassan also submitted a list of witnesses, and especially he submitted that till completion of examination of 5 numbers of witnesses,
months deadline was given. 6 months elapsed thereafter. That part is already over, my lord.
No, we have submitted.
Yes, that's why I'm saying that part is already over. What is here in this, my lord, order? That part is over. Your lordship has directed to examine 5 witnesses. Those has been examined. In fact, my lord, your lordship has given 2-3 months. 6 months has elapsed thereafter.
No, we
So
could have
that's-
examined on 3 occasions. The
That
police
is-
was unavailable. So on 25/11, 29/11, 12/12, these are the dates which I have specifically shown to your lordship through a certified copy. So that my humble consideration till till the examination of Asghar Ali is concerned. That is my humble prayer. I have to be fair enough with the accused as well.
Yes, Mr.
My limited submission will be that the lordship need not constrain itself as to, my lord, the examination of only the vital witnesses, my lord. Because this petitioner, my lord, has a history of influencing official witnesses, my lord, official persons, my lord. If your lordship looks at the charge sheet, in fact, the team of doctors who did the first autopsy, they were also made accused. The magistrate who conducted the inquiry, the inquest, he was also an accused in this case, my lord. If your lordship will kindly see the charge sheet. So there is no guarantee that this person, after coming out of bail, he will not again, my lord, try and influence the other official witnesses, my lord. Lordship will kindly see the charge sheet. At page number 89. Here, my lord, the role of Ashirvad Hazarika, the ALRS magistrate, has been noted, and it has been clearly mentioned that, my lord, he had taken all the steps to protect the interest of the accused. At page number 91,
Yes,
last paragraph.
Ashirvad Hazarika.
Yes, 91, last paragraph.
Yes.
Investigation has clearly proved that the accused magistrate
No, page
willfully,
number 90 of pleading?
91 of the bail petition,
Oh, 91.
willfully, dishonestly, and wrongfully created the inquest report in order to protect the murder accused. This is the influence of the accused, man. And it's a very serious case, man. A minor girl was raped and allegedly raped and murdered. Then, my lord, will kindly see the page number 92, the role of the doctors. There also, my lord, during investigation, my lord, the police found these doctors, my lord, were also hand in gloves with the accused. They were also trying to protect the interests of the accused, man. All from, my lord, all these paragraphs, my lord, at page number 94 and 95, all these paragraphs clearly reflect the role of the doctors also. So, lord, my humble submission is that considering this is a very serious case, my lord, it's not that only the vital witnesses need to be examined, my lord. Since, my lord, there is not, I do not know about the trial, how it is proceeding, but since the last order, rejection order was on August of 2025, after that around 8 to 10 witnesses have been examined. So, 10. So, it cannot be said that there is any delay in conducting the trial. So, in these circumstances, my lord, prolonged incarceration cannot be a ground for bail, considering the fact that, my lord, the trial has been proceeding expeditiously. So, that is my humble case. Lordship will kindly take.
But can you tell us one thing? Definitely, you said that there's a history of even tampering with the evidence of the official witness, that is the doctors and the other circle officers and all. But those persons, those doctors and the circle officer or the police officer, they are there in the cause. I mean, list of the witnesses. They are also included here.
They have been made accused.
Or they are accused.
Accused now. Initially, my lord, they were officials, my lord, performing official duties, my lord. But because of their role, my lord, they have been made accused.
And now they are accused.
Yes. So it cannot be said that, my lord, after this person comes out on bail, he will not again try to perform all these antics which he had done earlier, man. That's my humble.
court itself, so what the all this time. Brother is saying that see, number of cases we are not on very I always comes up on bail at this stage and influence a vital witness. The qualification is only a principle of the fact. Because in two cases, we have seen that these are the things which needs consideration. Prolonged interaction, restoration, or figures of human state. Right from the case laws which has been referred in Matrimonial Gauhati's case, from the present, it goes to show that the evidence which is there on record cannot be considered. But
I'm not asking for the consideration of the case, my lord. If my learned friend argues, going on arguing this case, same way, my lord. That's why I was not submitting on merit, my lord. That's why I was not submitting on. But your lordship has given an order last occasion, my lord. Only on that point I was asking, praying, my lord. Your lordship has directed. That direction was followed. And that direction, in fact, they have not fully followed. In fact, 2-3 witnesses they did not examine. Other witnesses they have examined. Now they are saying some more witnesses need to be examined.
Well, we have pruned it. My brother Leonard Pratt has not properly heard. We have pruned it. It is for their benefit. We are not going to examine these witnesses. That means we have pruned those witnesses for the greater benefit of the trial. Because why will summon these witnesses? Unless and until it is required for the purpose of in the interest of education of the trial. So that is my very prayer. In the examination, at least the Pascal and other parameters is very clear at this.
Mr. J. Pine, the learned counsel for the petition. Also heard Mr. J. A. the learned special public prosecutor, and Mr. S. Does, the learned amicus for the respondent. This is an application which went through and will be received by the receipt. It is submitted by Mr. Pine that the present bail application has been filed after rejection of the earlier bail application dated 22/08/2025, wherein the court had specifically directed the learned trial court to examine 5-6 numbers of witnesses who were also named in the said order. After the in person to the order, the prosecution had already examined 10 numbers of witnesses, including all the witnesses which were named in the order, and hence considering this aspect of the case, the prayer for bail of the present petitioner may be considered. Mr. Payal has submitted that he till date the accused is in custody for 3 years, 7 months, and 18 days. So, considering his long period of incarceration also, he may be enlarged. Mr. Payal has submitted that out of 96 numbers of cited witnesses, 43 numbers of witnesses have already been examined by the prosecution, including all the vital witnesses. And most of the remaining witnesses are some of the official witnesses. And the question of tampering or tampering with the evidence of those witnesses also does not arise at this stage. The accused, being the permanent and president of the Episcopal, he will provide sufficient security to the satisfaction of. Next paragraph. Mr. Hassan, the learned special PP submitted in this regard that out from since 22/10/2025, that the last order of objection, the prosecution has already examined 10 numbers of witnesses, including the named and the vital witnesses. However, some of the witnesses prosecution did not examine, as those were not considered as the vital witnesses for the prosecution. However, Mr. Hassan submitted that one Asghar Ali, who could not be examined by prosecution, is one of the vital witnesses who saw the entire incident for the first time, when the petitioner even sought for help in bringing the dead body of the deceased. Mr. Hassan accordingly submitted that the vital witness of the prosecution, and hence the prayer for bail may be considered by the learned trial court below after examination of said Asghar Ali. Mr. Hassan further submitted that on 3 occasions, that is on 25/11/2025, 29/11/2025, and 12/12/2025, they brought the witnesses, but those could not be examined due to absence of the learned presiding officer. In that context, it is submitted by Mr. Payam that though the witnesses were called for, but on the last occasion, as well as on the next date also, said Asghar Ali, which is considered to be one of the vital witness for the prosecution, was not called for to be examined. He further submitted that the delay in there's a sufficient delay in the trial of the prosecution, and the accused petitioner is in custody for more than 3 years, 7 months, which even violates his right under Article 21 of the Constitution. Next part, Mr. Das Dilanet Amicus submitted in this regard that some of the vital witnesses are yet to be examined by the prosecution, and he further submitted that it is not a case that the petitioner would not hamper or tamper with the evidence of the official witnesses, as he has the earlier history of tampering the evidences of official witnesses, which reveals from the charge sheet which is filed against the present petitioner. Earlier, some of the police officers as well as some medical officers also were trying to protect the interest of the accused, and those official officers are now booked as a accused person in the present case. Accordingly, Mr. Das submitted that only considering the length of detention, the petitioner cannot be, the bail petition cannot be considered, as there are as the probability of the hampering or tampering with the official witnesses also cannot be denied at this stage. Mr. Das further submitted that it reveals from the case record that within 1 year, 43 numbers of witnesses were already examined by the prosecution, and thus the trial is also going in a good pace, and hence it cannot be considered that there is an unnecessary delay in the proceeding proceeding and the prosecution proceeding to uh, to for violation of Article 21 of the Constitution. Mr. Das accordingly raised a main objection and submitted that in case of the present petitioner cannot be considered at this stage. Okay, I have recorded your part of submission. Rest part I'll certificate copy. If you ask.
With regard to my learned friend submission, my lord does. I want these are allegations. Definitely, my lord, in the search sheet there are allegations. My lord, the hampering and tempering, those are allegations only. Those are not yet proved.
But those persons, that's why I have asked Mr. Das.
Yes.
What about those persons, whether they are witness? He is saying that no.
They are not.
Now they are the accused.
They are the accused, my lord. They have been granted.
That's what shows.
Yes.
This shows that they are the accused person because they were trying to protect the interest of the accused.
That is their
So does he saying that there is a history of
my lord, that is allegation is there. Definitely that is, my lord, it's if we go, my lord, I actually I don't want to.
No, they are not listening on merit also.
Yes.
Yes.
That is on merit, my lord. It's if those persons, my lord, doctors, my lord, the doctors, I don't know anything about doctor. Who is that doctor? I have no, my lord, personal my lord, connect. I don't know who are those, my lord. A constable, my lord, can he influence the IPS officer? My lord, in fact, my lord, in this case, in fact, my lord, SP, additional SP, OC, the doctors, my lord, these all are some, in fact, my lord, out of these, this was not a case at all. In fact, when the chief minister visited the press, then only all this occurs, my lord. There are some political games, my lord, on for who is this has happened. Otherwise, my lord, any constable, my lord, he's a SSB Zuan. Can he influence the IPS, my lord, the SP of a district, additional SP of a district? My lord, three, my lord, the doctors, my lord, the circle officer whom he did not know anything, never met.
But what is the what bound the prosecution to go for second
autopsy, my lord? That's why I'm saying, my lord, this when CM visited, then it was the dead body was executed. Then it was sent for forensic. In fact, the my lord, that's why I was indicating, my lord, second postmortem, while doing second postmortem, the same, my lord, experts in the second postmortem, they relied on the first postmortem report, whom they are doing accused, my lord. If they are relying the first postmortem report, I don't know, my lord, how it can be. In one aspect, they are relying, and another aspect, they are saying this is not proper. Can it be? Legally, it is not permissible. A document has to be appreciated. Part of the documents, part of the materials which are in my favor, that has to be accepted, and part of which not are in my favor, that has to be discarded. It's not the way. I'm not on that, my lord. Those are not merit. But as my learned friend is raising an issue that, my lord, I tried to influence. My lord, is there any specific proof that I did influence? My lord, that so far, my lord, the record, 43 witnesses has been examined. There is not a single witness, not in my lord materials that I, my lord, tried. That is my summary. I am not on merit at all. That's obliged.
May I please, lordship? This is that matter, lordship. Here last time
24 and 25. What is the position?
dying liquor, whether it is there or not, lordship.
Series day. Both are connected.
Yes, they are connected, lordship. They are all family members, lordship. Last time, lordship, they were asked whether the dying liquidation is there or not, lordship. Only to that aspect. For we know, lordship.
You're insisting that there was a dying declaration.
Yes, lordship.
So yes, sir. Whether there is an dying declaration.
Lordship, I have found that there is a dying declaration is there, lordship. However, I want to point out other things also, lordship. In the dying declaration, whatever it is.
Okay, then we will hear. Then you can.
Okay.
Yes.
Yes,
What do you want to submit?
Lordship, the first case, lordship, husband and father-in-law is the petitioner, lordship. In the first case, lordship, 24 item.
And FIR lordship only indicating that lordship, there is a dowry demand and torture and lordship that
Item number 24, husband and
father-in-law.